Swayam Prabha. Digital India. Educated India.
Dear students, welcome to this course of Law of Torts, Consumer Protection and Motor Vehicles. I am Dr. Anirban Chakravarti, Professor of Law of IIU LER Goa. It is a Bar Council of India's university established in 2022. I am currently working there as a senior professor and chairperson of the undergraduate program. Among the various courses that I teach, Law of Torts, Consumer Protection and Motor Vehicles is one mandatory paper I teach to the first year law students. As part of that, I was requested to teach this course in the SwayamPrabha program, and I am extremely grateful to give me this opportunity and to part of this great initiative of the Government of India in disseminating higher and better legal education. Today our first lecture will be on the concept of nature and scope of torts. Now, torts is a very interesting subject. Torts generally deal with civil wrongs. The idea is that when a person suffers some loss, damage or personal injury, that may give rise to liability in two different sets of laws. One is the criminal laws, where the person who has committed the wrong will be punished. So, there will be a trial, and if he is found on the basis of the evidence presented that he has committed that wrong, he will be held guilty and will be convicted. But the victim does not have much to gain from there. And when the victim is seeking compensation and it is permissible in law, then in that case loss or damages caused by the person is remedied through compensation, and that falls within the category of civil wrongs, which is covered under the subject that we are going to be dealing with in this course, Law of Torts. Now, torts have primarily the emergence through judicial disposition and common law in England. I will come to the evolution of torts, but over times this judicial evolution has also given way to legislative incorporations, and torts have been also legislated. So, one of the areas where liabilities which were earlier dealt with common law has now been legislated is consumer protection. So, consumer protection can be considered as a form of a statutory torts. Similarly, motor vehicles liabilities or accidents caused by the motor vehicles and the liabilities arising from that was also earlier covered under the scenario of Law of Torts, but now it has also been incorporated into statutory provisions of the Motor Vehicles Act. So, these are the three areas that we will cover. The lecture for today will be mainly focusing on these four important topics: meaning and scope of torts, origin, development of this branch of law, definition of torts, and distinguishing torts with other branches of law such as contract, quasi-contract, crime. Now, we will first start with exploring what is the meaning of torts. The term tort is derived from Latin term called tortum, or meaning twisted. Now, the idea was that when people were acting in the society when they came into the society, there was need to protect everybody's life and property. Now, in that case, if there is no legal regulation or legal rules which can protect, then everybody's safety, economic aspirations and the social fiber will all break down. So, for that reason, this maxim of twisted acts to be penalized under the principles of law of torts evolved in our society. Now, originally, as I said, law of torts was mostly delivered through the mechanism of judicial disposition. So, when and how this law of torts were or how and when torts remedies were provided, that was based on some duty. So, everybody in the society has certain duties. Now, when you are supposed to perform that duty and you commit a breach of that duty, and this duty is independent of an agreement, that gave rise to the civil cause action, which is compensated by damages in the form of law of torts. Now, let me explain what do I mean in this statement. Now, duty means that we have certain duties. For example, we have duties to our parents, we have duties as parents towards our wards or children, we have duties towards our society, we have duties towards certain legal functions. For example, the Constitution of India has a chapter called Fundamental Duties. So, therefore, there are duties that are prescribed by laws, and there are duties which are prescribed by society at large. Of course, we are principally restricting our scope to duties which are arising from law. Now, the interesting point here is that some of the duties can be through contract or agreement. For example, a person enters into a agreement with another person for sending him 20 buckets full of oranges on a particular date, for which he is supposed to get a particular price from that other person. Now, he grows the orange, collects the orange and sends that to that other person. So, now what is the duty of the other person? The duty of the other person is to pay him the money which was agreed. Now, this is a payment of duty which is arising generally from the agreement. Now, it is a statute, there is a statute which also covers, but it is generally from the agreement. So, we call this kind of duties arising from contract, but there are certain duties which are not from contract, but directly from law. For example, the fundamental duties which are prescribed by the Constitution of India. Now, these are duties or legal duties which are prescribed by law. Now, these are certain duties which are not arising from contract. So, law of tort was dealing with duties which are arising not from contract, so independent of contract, and these duties were breached. That means somebody was not fulfilling his duty. That is, I have a legal duty to not defame someone. What do I mean by defame is that everybody has a right to reputation. Everybody has a right to enjoy his reputation in the world, whatever he has earned. Now, if somebody illegally or without any appropriate reason or cause defames someone, X is a very nice gentleman, he has a government employee, he has a good family, he has established a name in the society. Suddenly, Mr. Y comes up with a statement from nowhere that X has taken bribe for the purpose of signing this order. Now, when Mr. Y is asked that what is the source of this information, he says, I heard from someone. Now, who is that someone? He doesn't know. Whether it is a fact or not, did he verify it? he has not done. But he made that statement to a third person, and the third person went and made that statement to another person. That another person made the statement. So there was publication. Now this publication is definitely affecting that person's reputation. He has earned his reputation. He is a government servant. He has usually never been engaged in any kind of unlawful activities. Now taking bribe is an illegal or unlawful activity. So somebody saying that is definitely a harm to his reputation. So this is a breach. You don't have a right to harm somebody's reputation. This is a duty by law. Now when you breach this duty, it is not arising from any agreement or contract. It is directly arising from law. Like our earlier example was where the duty was arising from agreement or contract. In this case, the duty is arising directly from law. Law says that everyone has a duty to not disrepute or not harm anybody's reputation without any appropriate ground or appropriate reason or factual basis. Now when somebody breaches this duty, which is independent of contract, and it is found that there is no justification, it is not supported by actual fact or it is not true, then it is a clear case of a defamatory statement which is affecting the reputation of that person. So therefore it is giving rise to a cause of action in civil law. And what is the remedy? The remedy is compensation. So when his reputation is lost, he can go to the court and file a cause of action saying that this person, without any factual basis, without any justification, has disreputed me by saying that though I am a government servant, I am an honest government servant, but he kept on saying to many people that I have taken bribe. This is a great harm to my reputation. So this has given me the cause of action, and this is a duty by law, and hence please compensate me for the loss and damage that has happened to my reputation and my image. So court will then determine what kind of, there are measures and methods. We will discuss that at some later point of time, and by mechanisms of calculable damages, the court will provide the compensation to that person. And this is what is the subject domain of law of tort and implied in law. So this duty, as I said, the assumption is that everybody has a duty to not harm anybody's reputation, or it is a duty of everybody to not unnecessarily harass anybody mentally or physically. These are implied by law. So everyone has a duty of care towards everybody. That is the assumption, and on this assumption this duty is being implied by law. Okay. Now principal aim of law of torts, as I said, is to compensate victims, to give compensation, because in law of crimes the wrongdoer would be sent to jail, but the victim will not get any monetary loss if he has suffered any benefit or any other form of benefit. But in civil law there is no question of sending the person to jail, he will get compensation. So he has to pay compensation, and person committing tort is called a tortfeasor. So any person who has committed the tort, he will be considered as a tortfeasor. Now coming to how this law of tort has evolved. Now from an Indian perspective, you need to understand that in India we were a society which was more a duty oriented society than a right oriented society. So our conceptions of how individual duty is to operate, how this social fiber is to be maintained, when and somebody can get compensation for some kind of a loss or harm caused to his any legal duty not fulfilled by the other person, are kind of quite different from the Western society or the Western model where the law of tort has emerged. So in the early ancient and medieval India, we did not had so much development or so much evolution of law of torts. It was very narrow conception, and it was largely related to a very narrow area in our ancient Indian law. It was because, as I said, more than right, it was more duty centric. So anyway, we were more duty centric society. So duty was supposed to be the most important purpose of our society, our social living, and therefore we were automatically entitled that each one, if fulfills their duty, everyone's right is protected. But in a Western society, it was more of a right oriented society. So individuals' rights were given more priority, and therefore the corresponding duty was in that way not to affect somebody's right. Largely the evolution of law of tort in India has been a product of the British rule. So when the Britishers came to India, as we know, they brought their law also with them. Initially they were administering this law only to the British citizens and the persons who are directly employed with the British company or residing in the British territory. But slowly, this laws also assimilated into the larger section of society, because it was a 300 years of colonial rule. So therefore it was quite a long period of time. So slowly law evolved. Moreover, English people also had limitations to understand in certain situations, where largely one side an Englishman was involved and a native was involved, and it was something which in their society or in their legal system would fall under tort. What would be the corresponding legal consequence or the legal principle applicable under the law of the native? So in those cases they used to apply their British law. So therefore that's how torts gathered into India and started evolving and through judicial decisions, judicial principles. The Indian law of tort is based on English law however, the Constitution of India does actually recognizes this, and in Article 372 of the Constitution has been interpreted to continue also as common law principles are unapplicable in India. So the Indian law of torts is based on English law. However, in the post-independence era, we have declined to say that our law of torts is completely the English law of torts, which was earlier the claim that because it was largely brought and developed by the Britishers, so we did not have any law of torts. Whatever the law of torts in England is the applicable law of torts in India. Our Constitution in Article 372 in the post-independent era departed from this principle and said that no, it is not debatable that English law has contributed and may continue in some form in the application, interpretation or formation of the principles of law of torts in India. However, Indian law of torts is separate, and the common law principles cannot be applicable or cannot be unapplicable totally in India. So it's a mixed model that we have followed. Okay. Now, law of torts or civil wrongs in India is thus also largely British, but in many areas it will also, you will find its own Indian color or own Indian characteristic. Now, the example of such an area where the law of torts which were in question, the Indian courts was reluctant to use the British principle, and it said that it is either going to use an Indian sort of an approach. If Indian approach is not available in such scenario, then it will apply the principles of justice, equity and good conscience. So Indian law of tort has been therefore highly influenced by the principle of justice, equity and good conscience also. So in this case of Rotas industry versus Rotas industry, Indian courts have before applying any rule of English law saw that whether it is suited to the Indian society and the Indian circumstances. Now this particular case was involving a dispute between the labourers and the industry owners, and there was a question of English tort of conspiracy. Now English tort of conspiracy was whether applicable in the same form in Indian society was a question that Supreme Court in this case was faced with, and Supreme Court was of the view that we have to see before applying a principle of tort law which is applicable in India, in England, to the Indian scenario, looking at the social factors and the conditions prevailing in these two countries. Now, if the conditions of employment, if the conditions of employee-employer relationship, if the social conditions of labours are quite different between India and England, then those principles of English system cannot be directly imported into the Indian law and will and be used for interpreting those provisions or resolving a dispute. So, the circumstance social factor will be an important, and there are several such illustrations that we will come across over period of time in this course. The most fundamental is the case of strict versus absolute liability. We will come to that discussion. Just I am for the purpose of explaining this point, giving this illustration. Now, in England, if somebody brings into his land some item or some substance which is inherently dangerous, and he brings that which is also not part of the natural use of his land or natural use of his things, then in that case what happens is that he has to take complete care that that substance does not leak or that the substance does not escape. If that substance escape even without his fault, then in that case the person, the owner of the property who brings this will be held strictly liable. However, say if I give you an example, the well-founded case of Raylands versus Fletcher, wherein the owner of a land dug a big pond in his land for the purpose of some industrial region, and there was areas where there were some weak shafts, and he brought a lot of water, and that water was stored in that pond or the water tank. But because of the shaft areas which were weak, not adequately inspected by the particular third person who was constructor, engineer and the construction company who was employed, in this case the water leaked and the water escaped and caused havoc damage to the land of his neighbor. In that case, the neighbor filed a case for compensation, and the English court had allowed compensation under applying the strict liability principle. But at the time of applying the strict liability, the English court gave 3 exceptions. One was inevitable accident, not inevitable, plaintiff is the wrongdoer, where the plaintiff is a wrongdoer, or there is a inevitable or an act of God, an accident of that nature, then in that case the defendant will be exonerated. Now, when a similar question arises with escape of a toxic gas from a industrial sector in Delhi, in the case of MC Mehta versus Union of India Shriram Shriram gas leakage case. Now, Supreme Court there said that we will apply the English rule, but we will apply to Indian scenario, and we will based on the Indian social and Indian circumstances, and hence we will not allow any defense to be pleaded by the defendant. If he is running an industrial sector which consists of toxic materials or toxic gases, and if those toxic elements escape, he has to bear the liability and the consequences. He cannot take any shield or any play defense for that purpose. So, there is a modification, whereas in the English rule we see in subsequent cases the modification has been extending the extending the defenses by adding more defenses, but in India we have seen a more stricter rule. So, therefore, this gives a clear example of how Indian courts have applied principles of English law in interpreting or applying provisions of law of torts, but they have departed, and they have departed on serious note, creating a sort of an Indian jurisprudence or Indianized jurisprudence based on the Indian social milieu, Indian requirements. Now we are at a point to discuss the most important aspect. I have been talking about this word torts, but I have not made an attempt. I have given you some circumstantial or surrounding issues, but I have not given a straight definition that what is torts. I said it's a civil wrong, it's breach of duty, this duty not arising from contract, it's compensated by civil damages, all these things. But I have not given you a direct definition. The reason is that it is very difficult to give a straitjacket definition of the term law of torts. Very difficult. The simple reason is that this law of tort is a evolving subject. So for that reason, any subject in law is a very evolving discipline, evolving subject. So giving a comprehensive or a definite definition of terms in law is very difficult. However, that doesn't mean that definitions have not been attempted. That doesn't mean that a functional definition cannot be provided. So a functional definition of law of torts have been attempted by many scholars, courts all around the world, some statutory mechanisms also. One of the most eminent scholars, whose book is regarded as a very important literature in the field of law of torts, is Winfield. And in Winfield's book, the definition that Winfield gives to law of tort is something like this. He says, law of torts exist for the purpose of preventing men from hurting one another, whether in respect of their property or their presence, and their reputation or anything which is theirs. So from the very definition which is available on your screen, you can clearly see that it is impossible for anyone to give a precise attempted definition. What Winfield is trying here is to give a functional definition, and the functional definition he keeps it very broad. He doesn't fit it to any particular time or any particular frame. His definition is opened, and he says that what is torts? Torts is having a functional element for having this set of law, this branch of law. And what is that functional element? Tort exists for purpose of preventing men from hurting one another, whether in respect of their property or their presence or their reputation or anything which is theirs. Already when it comes to hurting men with reference to property, we discussed in the previous illustration. I said how one person cannot, even unintentionally cannot decline from his responsibility of damage caused to the property of the neighbor if he brings something which is inherently dangerous and not part of his natural use of the land. So even unintentionally he held liable. If somebody enters into somebody's property without permission, that's tort of trespass and he is liable, right? If somebody throws to some other's property a obnoxious element or obnoxious some thing, then that is tort of nuisance. Even I in my house bring something which gives a very foul smell and affects my neighbors, that's also a tort of nuisance. So tort therefore with respect to property, with respect to presence. So individual's presence can be also hurt at times. So his presence can be hurt, he can be wrongfully detained, all these aspects are covered. And reputation. So reputation, for example, defamation, other aspects. So property or individual, if somebody has a is to hurt, then he has to bear the consequence. So the definition, therefore, that's why it's a functional definition, which is trying to say that the purpose or the end of law of tort is to prevent men from hurting one another in respect to their property, their presence, their reputation. Now, similarly, our Supreme Court has also tried to attempt. Now, one thing that is clear when we study, that this authority is not trying to give a definition which is time bound or which is bound to certain features. It is trying to give a more dynamic, more open-ended definition. Now, in this very famous case of Jayalakshmi salt work, in this case I will briefly tell you the facts. Of course, we will discuss this case in subsequent discussions during negligence. There was a land which was adjacent to seabed, and there were some villagers, and to prevent the salt water from entering into the village cultivable land and damage their agricultural lands and other property, some embankments were built. Now these embankments were not natural, these were artificial embankments which changed the course of the flow of the water. Now the flow of the water after these embankment or artificial dikes were built affected the plaintiff's property, which is his factory and his godown. Now he were informing that and giving caution that it is still in a manageable condition, because the water is still not that high. But if there is a overflowing monsoon or there is a flood, then my entire factory is going to completely get damaged, and therefore it is for your negligence. And he, from the beginning when this program was instituted by the government, he started complaining the state against the state into various authorities. But the state defended on the social purpose of protecting the villagers life and their cultivable lands, etc., etc., was justifying the construction. Now over one particular season there was a heavy rainfall, unexpected, and there was flood which caused overflow of water, and the embankments could not able to protect, because a high volume of water was there, and the water overflowed and completely damaged the factory and the other features and other buildings of the plaintiff. So the plaintiff filed a case. Now the state here was the responsible other side or the defendant, and the state made many attempts to justify that they have not committed any wrong, there was no negligence on their part. They also tried to place defense of state's acts are not to be held liable because state is exempted. So many defenses were pleaded. There were also pleadings relating to limitations, but the main point was that in this case, can this be a case for negligence or this will be a case for a new tort? Now Supreme Court here obviously gave a favorable decision for the plaintiff, but more importantly what the Supreme Court held was that they were trying to look at, again from a functional perspective, what includes or what involves in law of torts. So Supreme Court said, and I quote, "Truly speaking, entire law of tort is founded and structured on morality, that no one has a right to injure or harm others intentionally or even innocently." Now see the connectivity between the definition of Winfield and the Supreme Court's definition of law of torts, or attempted functional definition of law of torts in Jayalakshmi salt case. In the Winfield's definition, it says that law of torts exists for the purpose of preventing men from hurting one another, whether in respect of property or presence or reputation. And what Supreme Court observes in Jayalakshmi salt? Supreme Court says that the moral basis or the main objective functional perspective of developing this branch of law, which is law of tort, is to say that no one has a right to injure or harm others intentionally or even unintentionally. So the connectivity between two, one is an English jurist who is giving a definition based on the English perspective, and the other one is an Indian sovereign court of highest apex court which is giving a definition, and you see the functionality. So therefore globally law of tort has never been attempted to define on any comprehensive or straitjacket matter. What law of torts have been tried to be defined is on the basis of a functionality. What is the end purpose it wants to meet? So the purpose end that law of tort is supposed to meet is to ensure that nobody intentionally or innocently injures another person, and this injury may be inclusive of property, his self, or his reputation. Therefore, now Supreme Court in Jalakshmi case goes further and says that therefore law of torts definition is a dynamic flow. It says that therefore it would be primitive to class strictly or closely ever expanding growing horizon of tortious liability. So therefore tortious liability cannot be blocked or cannot be put into a straitjacket or a comprehensive definition. For social development, orderly growth of the society and cultural refinedness, liberal approach to tortious liability by the court is more conducive. So over the factual approach, the courts will see that what kind of tortious liability can be developed and can be implemented. So the court leaves torts definition more like a flowing river. However, what it says and it does, as like Winfield gives a functional definition. So the function and the purpose of torts. Now, as I said, that law of tort is an independent. By this time now you have understood that law of tort is an independent branch of law. And it is a branch of law, and it is a branch of law existing parallelly with several other branches of law. Now, how law of tort is therefore different from this branch of laws? This is also an important thing to know, because when you say that this particular case or this particular liability is arising from the law of torts and not from contract or from crime or from quasi-contract or from some other aspect, then you have to know that what is the difference that exists between each set of these laws. So now I am trying to give you the last topic, subtopic of today's lecture. This lecture is the distinction of law of torts from some other branches of law such as contract, quasi-contract and crime. Now we start with contract. Now why do we start with contract? Because as contract is also a very, very important civil binding. It is the very basic binding of social business, social agreements, legal agreements. So it is the very fundamental feature by which economy of the world moves, and it is that set of law which is equally a civil law, because if there is any breach of contract, your remedy is only in compensation or damage and in no other form, right? So therefore, what is the differences between contract and torts? The first and the most important difference is that contract is founded on the basis of consent, whereas tort is inflicted against or without consent. Now what does this mean? What does this mean is that the foundation of contract is consent. Two persons, when they agree or there is a meeting of mind, consensus ad ideum, then only a contract emerge or an agreement emerge. There has to be agreement or meeting of mind. In tort, there is no meeting of mind, there is no need for an agreement. Hence, therefore, consent is not an essential aspect, rather it is actually not an essential aspect. In most of the cases, it is without consent. Now, when somebody harms somebody's reputation, there is no consent. When somebody causes assault to someone, there is no consent. So consent is not there. So contract is founded on consent. Tort is usually not founded on consent. Now tort is a violation of right in rem, whereas contract is a violation of right in personam. Now this is also a very important aspect. What is right in rem and what is right in personam? What do we mean in our legal parlance? Right in rem means that a right which a person enjoys against world at large. Now I have a right of bodily protection. When I go anywhere, nobody has a right to harm me, my physical being. This is a right in rem. You need not require to have any particular person over whom this duty not to harm me vests. It is a right that I enjoy against world at large. So anyone who affects my right, I have a cause of action against that person. But right in personam is on the contrary, right between two individuals which are entered in through consent, like contract. So contract happens only when there is a consent. So therefore it only also applies between those two set of individuals or those two set of parties who have agreed to that contract. It does not go beyond them. So all rights, all liabilities, all duties, all consequences are related among them. Any third party who will attempt to enter, he will be called off, or he will be prohibited by the rule of contract called privity to contract. So therefore contract only is a right which is between only parties to the contract, so it's personam, it is personally, whereas rem means world at large. In case of tort, the third distinction, in case of tort, the duty is one imposed by law and is owed to the community at large. Whereas in case of contract, the duty is fixed by will and consent of the parties and owed definitely to the parties or the persons only. So what happens, as we have seen over our discussion, that in torts there is no limit. It is not that I have agreed with him and that is the reason why he has a duty, or I have a right. It is certain rights that are existing by virtue of law, and therefore those rights are my rights, and anyone who violates is a breach to my right, and therefore everyone in the world has a duty to ensure that those rights are not violated. Whereas in contract, it is only through consent that the transaction is established. Hence the transaction, if it is established only through consent, it only applies to the two set of parties. Therefore, the duty, if there is any arising in the contract, it is only between the two set of parties. There is no world at large duty or any duty owed to any person outside the contract. The fourth distinction between torts and contract is that in breach of contract, the damages are something which can be estimated. Because what happens, contract is an agreement. I and X agree that I will supply him 20 barrels of wine and he will pay me 20,000 rupees, 1,000 at the price of 1,000 rupees per barrel. Now if I don't supply him 20,000 barrels, he is supposed to again supply to another person in turn, which he has also entered into another contract. So he will suffer a loss of 40,000 rupees. So therefore, if I don't supply, if I cause any breach to the performance of my contract, the estimated value of damage that the court will determine without any hesitation is that 40,000, which is the agreed loss. This is called liquidified damages. So what damages can happen if there is a breach of contract, or if the contract is not filled? Something that can be estimated by the parties themselves or from their transaction, and it is called liquidified damage. But what damage I have suffered because somebody has called me a thief? Now I am a professor of law, I have certain reputation. Now if somebody calls me a thief, now what damage to my reputation has actually occurred? It is very difficult. There cannot be a pre-estimate. To what extent this message has spread? Who are the parties or who are the people who have seen this message? In what forms? So all this, how for what period of time these forms in which this message will be there. So all this will be quantifying a scenario which is not to be estimated. So therefore unliquidated. So therefore, when it comes to damages, now in contract the damages can be paid in form of liquidated damages or estimated, but in torts it is usually unliquidated damage. Damage cannot be estimated. And second, in torts, harms can be caused to not only the property but to physical being of the person, right? Somebody by negligence can actually cause such harm for which I become permanently impaired to a state of vegetative body. Hence, therefore, in this looking at the scenario that what is the consequence of my tort and what is the damage that I caused, the court can give some types of damages which are like exemplary damages, aggravated damages. These are something more of like punishments or deterrence, so that nobody should in future get involved into that. Now, however, there are some types of cases where contract and tort can actually operate at the same time. For example, you hire a CA, a chartered accountant, or a healthcare professional, and enter into a contract with that person for services of professional nature. For example, with the CA, accounting and financial services, with the healthcare person, healthcare services. Now, if that person commits some negligence for which you suffer a loss, now that can be both breach of contract losses and can be remedied through compensation for breach of contract. At the same time, it can be parallelly sued for negligence causing damage and can be damage claimed for civil action. Now, usually what the courts have said is that parallelly, if there is from a same cause of action, a civil action in tort and contract are available, then parties have to choose one. They cannot usually prefer to seek compensation from the same party for the same transaction for both tort and contract. There are some cases where usually this has arisen in cases of consumer protection, where there has been a breach of contract case of a service professional as well as a negligence, and the person, after filing a case in consumer forum, has also moved to the civil court and filed a suit for negligence and damages, and there the courts have said that you have to prefer any one. So there are some examples, but there are possibilities, some areas where it can lead to both tort and contract. A similar cause of action can rise a relief in both tort and contract. Now, moving to the second branch of law where we distinguish between tort is quasi contracts. Now, we have discussed contracts. Now, contracts are fundamentally agreements. Now, the Indian Contract Act provides certain requisite features in order to make an agreement to a contract, such as there has to be a binding consent, there has to be an offer, there has to be an acceptance, there has to be a consideration. The parties should have the capacity under the law to enter into a contract. There has to be definitely free consent. So all these aspects have been prescribed in section 10 of the Indian Contract Act. So Indian Contract Act section 10 says that what agreements are contract, and the simple definition that section 10 provides is agreements which are enforceable by law are contracts. So if you fulfill these conditions prescribed in section 10, then only those agreements become enforceable by law, and hence they become contract by virtue of that. But there are some kind of agreements, or there are some scenarios which looks like contract but do not have the essentially fulfill all the criteria of a valid contract. And this kind of transactions are called as quasi contract. Although the word quasi contract has never been used in the Indian Contract Act anywhere or any law, but Indian Contract Act in chapter 5 recognizes some set of transactions between section 68 to section 72, which it calls as relationships resembling or created by contract. So these are relationships or transactions which are resembles or creates by like contract, and they are called the quasi contract. Because why quasi? Because they do not fulfill the requirements of contract, yet the obligations created, the rights created or the duties created are more or less similar like contract. That's why they are called quasi contracts. So now with quasi contracts, torts can be also contrasted. Now with reference to when we look at whether this is a matter arising from torts or contract, we see a quasi contract, we see there are certain similarities. Now what are the similarities? Now for example, law relating to quasi contract resembles to law of tort and differs. So duty in quasi contract as in tort is imposed by law. So unlike contract where the duty is imposed by the agreement of the parties, in quasi contract the duty is imposed by law. Now what is a duty in quasi contract? Like section 68 of the Indian Contract Act says that if there is a minor who cannot enter into contract, but he requires support like financial support or other means of support, and somebody has provided him. So that person, when provided him, has right to recover it from the minor, and there is an agreement, and that is a quasi contract agreement, right? Now this minor is not having any right to contract. So in a normal contract scenario, if minor contracts, it will be considered as a not enforceable contract, and it will be a void ab initio. However, if without a contract there is a tacit sort of understanding by which a person continues to provide minor some financial or other support with a clear understanding that it will be recoverable from the minor's asset or minor's estate after a point of time when the minor becomes adult, later on the minor cannot decline. And this is the duty which the minor cannot decline, is not imposed by agreement or contract but by law. So that's like torts. In quasi contract also the duties are imposed by law and not by agreement of parties or by consent. However, there are distinctions also. Like for example, A pays money to B and B does not have any right on the money. So A pays by mistake and B is under no obligation to immediately not accept the money. But after he finds that this money does not belong to him or A has by mistake paid, he has a obligation to refund the money. So refunding becomes an obligation, and this is obligation or duty by law. So therefore, not accepting the money is not a breach of duty. So when first time A gives him the money and B takes it without thinking that whether the money is entitled to take or not, does not commit any breach of duty or any fallacy of obligation. However, once he discovers that he does not have the right to get the money, yet he continues to enjoy the money, that is where he fails the duty. So secondary duties in quasi contract is enforceable, primary duties are not, and this is different. In torts or contract, primary duties are enforceable. Now coming to crime. Now tort and crime, as I started with, are both attempting to sort of give relief to some kind of acts which are causing loss or damage, but in crime through punishment and torts through compensation. Now similar to contract, crime is also duty imposed by law and in rem. So if somebody commits murder, it's in rem, and tort also in rem. So there is lot of similarities between the tort liability and the criminal liability. How there are some 4 interesting distinctions with which I like to end. One is tort is an infringement of private or civil rights belonging to individual, whereas crime is a breach of public right. So this is the first time we are understanding public right. We will see later on. Public rights are those rights which are social rights. It is not between privates. I allow somebody to enter into my house or not allow enter into my house is a right that I enjoy in private. But I cannot stop anybody to enjoy roads. Right? Walking on the road is a public right. Entering my house is a private right. Walking on the road is a public right. So therefore, crime is a violation of public right. Tort is violation of private right. In tort, wrongdoer has to compensate by money. In crime, by punishment. Action of tort is brought by the injured party. So tort action is brought by the injured party or the plaintiff. In crime, prosecution is the state. And tort actions are not punitive in nature, as I said. It's compensatory, whereas criminal actions are punitive in nature. So I therefore sum up this discussion, as I said, that tort is a functional approach to protect or prevent individuals in the society to be not hurt with reference to their property, their presence and their reputation, and so on. It continues to grow, and it is a very important branch of law. It started its evolution through common law, but over time it has been statutorily also enacted in several countries including India, and it continues to grow, and it's a very dynamic set of law and is very important, and I am sure we will continue this discussion in our next lectures. Thank you for your attention and hope to see you in the next lecture.